afternoon, everybody, and welcome. My name is Keith Bybee, and I direct the Institute for the Study of Judiciary, Politics, and Media here at Syracuse University. And each spring, we sponsor a lecture series on law, politics, and media that is co-sponsored by this man here, my colleague and spiritual advisor, Roy Gutterman, who heads the Tully Free Speech Center. The aim of the speaker series is to bring out distinguished practitioners from the fields of law, politics, and the media, and give them a chance to reflect on not only what they do, but on intersections between these three domains. Today we have our final speaker of the semester, and we like to believe that we saved the best for last. That's what we like to believe. We may be wrong, but it's what we like to believe. And we're joined today by Dahlia Lithwick. Dahlia is senior editor at Slate, and in that capacity she writes Supreme Court dispatches and jurisprudence columns. Her work of legal journalism has been widely published. You can see what she's written in Newsweek, New York Times, Harper's, Washington Post, Commentary, as well as other places. She received the Online News Association's Award for Online Commentary for her Supreme Court coverage in 2001, and again in 2005 for a series she co-authored on torture. She's the first online journalist who has been invited to serve on the steering committee for the Reporters Committee for Freedom of Press, an invitation I believe she accepted, so she sits on that committee. She has a BA from Yale University and a JD from Stanford. She has practiced law. She clerked for Proctor Hugg, was the Chief Judge of the Ninth Circuit Court of Appeals at the time. She's co-author of the book Me versus Everybody, Absurd Contracts for an Absurd World, which is a legal humor book, and also author of I Will Sing Life, Voices from the Hole in the Wall Gang Camp, about 7 children from the Paul Newman camp with life-threatening illnesses. Dahlia Lithwick, in addition to all these achievements, is really just a fun person and just great to have around. And so we're really so glad to have her here today. Please join me in welcoming her.
Thank you. Am I in the right place for? I'm not supposed to move.
To the right, keep your left, my right.
Okay. Yeah? Okay. I have like a 2-inch margin that I have to be in for framing reasons. So thank you very, very much to the Institute for the Study of Justice, Politics, and the Media. Thank you to all of you many of you who have strained to get me here with multiple emails that I don't always answer. And it's really a pleasure to join you today. I'm going to talk about 2 things, maybe 3 things. And more or less, I want to talk about how Supreme Court reporting has changed. I've been doing this for 12 years, which seems like an enormously long time, but in fact, compared to most Supreme Court reporters who have been on this beat for quite literally 20, 30, 40 years, Lyle Denniston, who covers the court for SCOTUS Blog, says, and I can't do the math to figure it out, that he has covered 1/3 of all justices in the history of the court in his time covering the court. How can that be? But he brags about it constantly. So it's a beat that people really end their careers like feet up. Nobody likes to be off this beat. But it's changed very dramatically, and so I want to talk about how it's changed, and then I want to think a little bit about, I think I'm going to stop with my watch now. And look at the big clock. I think after that I want to talk about how the court has started to react in recent months, I think, to a change in the media, and how I think it's starting to affect doctrine and affect the way the court thinks about the public, about us, and it's something I think we really need to have a conversation with sooner rather than later. So I'm going to start with the very, very obvious premise that the court always has been and always will be 2 institutions at once. On the one hand, and Keith has written about this more eloquently than anyone, but on the one hand, it is a political institution driven by political forces, political players for political reasons are put on the court to achieve ideological ends. At the same time, it's different. It is a sort of oracular, sacred institution. It is separate from the political institutions. It is shielded from the political branches. One of the reasons for lifetime tenure for the judiciary is so that it is not a political institution. And at any given moment, the court is completely political and also completely judicial and driven by this work of triangulating against the law and the Constitution. And it is very hard to hold both those ideas in your head at the same time, but that is the job of a Supreme Court reporter, to believe both those things, those utterly irreconcilable ideas about the court, always at the same time. So, this is why we're all drugged, because it's not actually possible to hold both those thoughts in your head at the same time. And I want to argue to you today that it is in the court's interest to only promote that second narrative, to promote the narrative that the court is different, that it is apolitical, that something happens when you put on a black robe that makes your former self fall away. The language Clarence Thomas used at his confirmation hearing is, once you're on the bench, you strip down like a runner. Everything you were before is gone. I know the image of naked justices is quite alarming, but so go back to the black robes if that's easier for you. But the idea that what you were before has nothing to do with what you do on the bench. And it's a narrative that famously Chief Justice John Roberts put in terms of, we're umpires, we call it balls and strikes, just plug us in and we go. We just divine the law, and it has nothing to do with who we are or what we believe or who appointed us. And this tension between the story that most newspapers tell, right, sharply, ideologically polarized 5-4 court, and the story that the justices want to tell about how they're different and they are immune from the political winds. They don't read the newspapers. They don't care about the polls. This tension for the court is easily resolved by suppressing that political narrative. And there's a lot of ways that the court does that. But think about how hard they work to suppress the political narrative. And the example I want to give you is Justice Stephen Breyer, who put out a really, really interesting book this year called Making Our Democracy Work. And the entire premise of the book is that the court is not political. The entire premise of the book is that whatever it is that we're doing when we're on the bench, it's not politics. We're making law. And I've always thought it's really interesting that Justice Breyer and Justice Scalia go out every year, and they do this little dog and pony show at various places, more like Punch and Judy. They just kind of bat at each other and shout at each other. And they talk about originalism and constitutional interpretation and active liberty and judicial activism, and they disagree on everything. But the one thing they agree on is that judges are not political, that what they are, first and foremost, is sort of sacred oracles plugged into that great jurist in the sky, and that what they are overwhelmingly is in agreement with one another. And both Scalia and Breyer, who, as I said, disagree on everything, like to say over and over again that America doesn't know that most of our cases are decided unanimously. They're decided 8-1 or 7-2. The court, most of the time, is doing the work of judicial, high, lofty reasoning. And occasionally, there's a few moments where they slip and it's a little political, but for the most part, the narrative they want to sell America is that what the court does is fundamentally not politics. And in promoting his book, Justice Breyer was so eager to make the point that justices are different, they're shielded, they're apolitical, they're quiet, they're reclusive, that he went on CNN, PBS, NPR, ABC, C-SPAN, NBC, and every major newspaper to make that point, that we are not political. I'm just telling you, we're reclusive and quiet and scholarly. So if I'm right that all 9 justices are working very, very hard to promote this narrative about how justices are different and they really are great thinkers and scholars, and what they are not is ideologues, the only people who work harder at that than the justices to sell that narrative, I would submit, is the Supreme Court press corps. This is our raison d'etre, is to collude with the justices to sell the narrative that the court is apolitical and that the court is doing justice and they are interpreting laws and they are reading the Constitution, but whatever it is they're doing, it's not politics. And so today what I'm going to really talk about is that weird dysfunctional marriage where the court and the press corps collude in continuing to tell a narrative even though we all know that it's not true. Now, there are some systemic ways that the court suppresses the politics narrative, and there's ways systemically they've been doing this for a long time. The easiest one to just fix on as a metaphor is they suppress the politics narrative by having black robes, red velvet curtains. They pop out in front of the curtains like it's Shakespeare. They, for a very, very long time, if you wanted to read a transcript of oral argument, which people, interestingly, might do, it didn't say Justice Scalia, da-da-da-da, Justice Breyer, da-da-da-da. It said the court, the court, the court. Well, why would you do that? Why would you elide who is asking the questions as a systemic institutional matter? And the answer is, again, we are 9 brains in a vat. We are the court. It doesn't matter whether Justice Ginsburg asked the question or Justice Stevens, because we are speaking as the court. That's a systemic way that the court suppresses the idea that these are individuals and these are political ideas. There's another way that the court suppresses the idea that these are individual political actors. It's an obvious way, and that is they simply close the door to TV cameras, and they close the door to audio recording. And by doing those things, again, it downplays the idea that this is a court of individuals who are arguing and bickering. And it really plays up the idea that this is an institution that's fundamentally different, right? No other institution of government, including local government, including my kids' PTA meetings, are closed. But this is closed because we're different. And what we do is somehow inscrutable and lofty, and so we're going to make sure that the public can't come in and watch us do our work. What else do they do systemically? They don't tell you when they're giving a speech, the justices. They don't release information when their speeches are given. Try to get a hard copy of a speech that a justice has given. It's not easy. So they really try to promote the idea of themselves as not public figures. And Justice O'Connor always puts this very succinctly when she's asked, why are you all so wobbly about cameras and about speeches and about having a public identity out there in the world? And she always says, if you want to know what I think about public campaign financing, 4 corners of the opinion. You want to know what I think about affirmative action? It's in the 4 corners of the opinion. I don't have to add to it. I don't have to subtract from it. I certainly don't have to explain it. Everything you need to know about me happens in an opinion. And that's always been the position they take, and that's the way, I think, they've managed to obscure the reality that there are, in fact, 9 individuals with very different politics. The other thing that I think the court has done until very recently to kind of sell this narrative that this is not a political institution is that when the justices write books or make appearances, they're very scholarly. So Rehnquist used to like to write about impeachments that happened thousands of years ago. O'Connor likes to write books called The Majesty of the Law that, to the best of my understanding, are about, I don't know. But, you know, they certainly write long, long scholarly books that tell you nothing about who they are. Now, obviously, this changes abruptly when Clarence Thomas publishes an autobiography that tells you exactly who he is and what he thinks. But until that time, the justices really confined themselves in public to speaking about public matters and to talking about the court as a public institution. So, the press corps is the court's mini-me. We are exactly the same, but without the robes. But we really do, I think, espouse many of the same tricks and techniques to downplay the narrative that covering the court is like covering Congress. So, for instance, the United States Supreme Court press corps is the nerdiest, wonkiest bunch of people you will ever see. If you meet a congressional reporter, the chances are very good that they are picking something out of their hair because they've been in a dumpster looking for a scoop. And there's like lettuce in their hair from lunch. We are not scoop people. We don't look for scoops. There are no scoops. We don't have secret sources that whisper things to us. What we do, what we love to do, is read briefs. And I guarantee you, if you meet any 2 Supreme Court reporters on a Tuesday morning before oral argument, the likelihood that their conversation is about scoops and gossip is about 0. The likelihood that they're saying, oh my God, did you read footnote 7 in the green brief? I know. That's how we talk. And that's one of the reasons we stay on the beat forever and ever, is there's not a lot of beats that really want you to read footnotes, particularly in this day and age. But these are people who the way I've come to explain it, and I think it probably says it all, these are people who really think their responsibility is to cover the law. And so when we go into court and we're talking about an affirmative action case, we want to explain what the case is, we want to explain what the justices have said, we want to explain how the law is going to change going forward. What we don't care about is the justices. And so the way I've always come to describe it is we cover the court as though the justices are dead and the law is alive. And really we think that, oh my God, did you see what happened to the Dormant Commerce Clause this morning? That was insane. That's how we think. It's the way con law professors think, by the way. It is not the way political scientists think, but it is very much the way con law professors think, is to de-emphasize the justices, the role of ideology in politics, and to really emphasize that the thing that matters at the court, the end product, is the law. And most of us believe that. Many of us went to law school. If you go to law school, you have to believe that, because if you really go through law school thinking it's all just a coin flip or what Justice Kennedy had for breakfast or who their clerks are, I don't know. I would quit law school and go to film school. It's just too dispiriting to think it's all political. And most of us have really come to embrace what I call this false consciousness that what they do is so profoundly different. It is so lofty that we cover it that way. The other thing that we really do on the Supreme Court press corps, for good and for ill, is we concern ourselves with facts and not opinion. This is really the last press corps that still covers the facts. Very, very rarely will you find a Supreme Court reporter weighing in with an opinion on anything. And it's simply a press corps that feels it's not its place to conflate facts and opinion, even in an era where I would submit most every other reporter does it cavalierly. There's no line between fact and opinion. In most political reporting, I think the line between fact and opinion in Supreme Court reporting has not changed. It's as high as it's ever been. So how has covering the court changed? I've just described a bunch of 2,000-year-old fuddy-duddies who don't do anything different. I think a couple of things have changed very dramatically in a very, very recent and compressed amount of time. One of them was the advent of new journalism in the 1960s and 70s. The book The Brethren comes exploding onto the scene. And the focus is not the court as this revered oracular magic palace in the sky where law comes from. It's about politics. It's about public actors, what they do wrong, how they fight with each other, how they get their deals done. And a real scrutiny of those public actors, a sort of presumption that they need to be scrutinized. And the whole idea of new journalism was to discomfit the comfortable. And the court needed to be discomfited. And so that kind of changes, for the first time, the way the American public thinks about the court. So that's a piece of it. But I think the real big sea change comes with the advent of the Internet. Because the Internet suddenly makes everyone an expert on the court. You don't have to be in the court to cover the court anymore. And every law professor who can get access to oral argument transcripts, which you can get at about 3 o'clock on argument days, can cover the court as readily as I can. The difference is he's written a treatise, and I haven't. And this has created huge anxiety in the Supreme Court press corps. How do I add value if Eugene Volokh at UCLA has written a treatise about con law, and he can talk about oral argument and have something posted at 4 p.m.? What do I know? I'm just a guy who stumbles in and out of oral argument and reads a lot of footnotes. And that has really stressed out my colleagues in the press corps. Now, in addition to that, one of the simple things that's changed in journalism is speed. It used to be the case that I would come out of oral argument at 11 or 12, and we would talk, we would compare notes, have a little lunch, and file at 5 or 6 o'clock for the next morning's paper. Those days are over. Over. The wire services have something up by 11:30 or noon on argument days. I usually have something up by 3. Even the people who write for print, for the New York Times, for the LA Times, for USA Today, are expected to have something up by 2 or 3 o'clock in the afternoon. Now, obviously, that means we make a lot of mistakes, more mistakes than we used to. I also think it means that we write shorter pieces and pieces that are less reflective, but the trend is to go fast. And the trend more and more is, if you can podcast, great. If you can blog, great. If you can tweet it, even better. I once sat through a confirmation hearing where the person opposite me was simultaneously live chatting tweeting, blogging, and podcasting all at once. No idea if she saw the confirmation hearing, but she was reporting it. And I think this is a real problem, this idea that we have to go fast, 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 we have to be the first one out. And I think it's in natural tension with law, which tends to happen slow, 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 and really to reward being thoughtful and careful. But that's just the nature of journalism. We are all going fast now, and we're making mistakes. The other thing that's happened, and this is simply an interesting factoid, and do with it what you will, is that I can now cover decision days faster from my home than I can from being in the court, because I can't broadcast from the court. And so if I go into court at 10 a.m. and the decision comes down and Justice Breyer reads his 400-page dissent, I can't even begin to write about it until 11:15. I can't get out to write about it. You know what I can do at home? I can get on SCOTUS Blog and read their live ticker. And SCOTUS Blog has obtained permission to have someone sit in the lawyer's lounge, right? We're not allowed to broadcast from the court. You can sit in the lawyer's lounge and you can listen. And so SCOTUS Blog now, within about 4 minutes, is reporting live what's happening at court. So just think about that. Think about the physics of what it means that you can cover the court better from outside the court than inside the court. And then ask yourself what kind of crazy pressure that puts on Supreme Court journalism. The other thing that I think has started to happen, and this is really the nut of what has changed, is that anybody now with a camera phone is a journalist. And that means that when Justice Alito goes out to give a speech and he thinks that nobody's listening and it's not being covered, it's being covered. It means that when Justice Clarence Thomas gave a speech a few weeks ago at University of Virginia that was expressly off the record and expressly closed to journalists, it was on Politico the next day. Anybody who records anything, it's out there the next day. And this has led to an advent of the kind of gotcha personal journalism that you can imagine. The justices love it just about as much as you would, to have some stranger leap up in their face with a camera phone and say, oh, look, here's what you're saying, and it's going to be in the news tomorrow. And that really is new. And I think it's quite terrifying for the justices. So those are the ways that the beat has changed. And I've sounded kind of negative. I want to tell you there's a huge bright side to it. And the huge bright side is that legal blogs are tremendous. And that if you don't read Balkanization every day, if you don't read Volokh every day, if you don't read Rick Hassan on election law, you're not reading the very best stuff that is being written about the court. And that having just complained that I can't do it as well as Eugene Volokh, I want to tell you, I can't do it as well as Eugene Volokh. And that is an amazing, amazing thing that has happened within my lifetime, that law professors who we used to have to beg when I started writing for Slate, please, please, Akhil Amar, please, 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 please write something for Slate. And law professors weren't interested in being in the national conversation because they were writing their law review articles. And now we're beating them away because we really, really have created a world that law professors and the academy has thrived in and become not even just part of the conversation, but I think the center of the conversation. And I think it's so important because the quality of the conversation about the court is so very high. Okay. Why is this making the court anxious? Well, the court, remember, is trying to tell a story. And the story is that the court is different and that the court is special, and what the court does is law, not politics. And we are doing a lot of things that are undermining that story. And the best example I can give you of how I can tell that it's making the court nervous is its changed relationship with SCOTUS Blog. Because when SCOTUS Blog was launched only a few years ago, the court did everything they could to not cooperate and collude. Now the court absolutely cooperates and colludes because it's better to have SCOTUS Blog being the pipeline out of the court than someone else. And so they've created a kind of trusted symbiotic relationship with a blog because they trust the bloggers, they trust Tom Goldstein, the founder. And so suddenly the SCOTUS Blog is the closest thing we have in this country now to the court having a public press office. I mean, SCOTUS Blog is in a relationship with the court. I think that's really interesting and very new. The other example I want to give of how worried the court is about this narrative getting out about politics is the audio policy. And I talked about this a little bit at lunch today, so forgive me if you've heard it. But for 10 years, since Bush v. Gore, the court has had a policy that even though they could release audio, same-day audio of oral argument, they wouldn't. they would only do it once in a while. And the metric that then Chief Justice Rehnquist used in Bush v. Gore was, we're only doing it in important cases. What's an important case? I don't know. Could you tell us? No. I know it when I see it. So 2-3 times a year, the court would release same-day audio. And America would cluster around their radio like it was still the time of FDR. And we'd actually listen in on oral arguments 2 or 3 times a year. It was a crazy policy. Why? One, the court shouldn't be in the business of deciding what's an important case. Woe betide the guy whose case isn't important enough to be released that day. But much more importantly, the cases they tended to release same-day audio were always the explosive 5-4, angry, gay rights, affirmative action, abortion, death penalty cases. Those are not the cases. If America's only going to listen in on 1% of what the court does, don't have it be court sounding like Congress. Have it be the court sounding like a court. So it was a deranged policy that was the policy for 10 years, and a lot of us complained and said, look, you can give us same-day audio. We're not asking for cameras. We know we're not getting cameras, but give us audio. This year the court said, we're going to have a new policy. First of all, last year there was no audio. We requested it for many cases, none. And we thought, oh, this is interesting. They're going to give us no audio. This year they said, you know, you're right. We're going to have an open and fair and transparent audio policy in which we release all of the oral arguments at 5 o'clock on Friday, which is where news goes to die. And so now, if you're the one person in Washington who really, really, really wants to get Supreme Court news at 5:30 on Friday, you can listen to all the oral arguments, but your friends will be drunk in a bar. So this is their compromise with us. It's their way of saying, on the one hand, look, we're being open, we're being transparent. On the other hand, giving us something that is of less utility to us than before, than the hit-or-miss policy we had before. I think that's just another example of the court getting pressed to be more open, to let us in, and saying, okay, I'm going to let you in, but I'm going to let you in at 5 o'clock on Friday. And it's a real lesson, I think, in how the court can't quite decide how much it wants to let us in and how much it wants to lock us out. I think the final thing that tells me that the court is very, very anxious about the relationship with the press and the public is the utter failure of all of the justices, with few exceptions, I think, to understand there are no private spaces anymore, and that you can't go give a speech at UVA and not get reported. You can't go to an ACLU event and not get it reported. You can't, Justice Sandra Day O'Connor, put out robocalls in the middle of the night about an Iowa election and think it's not going to get reported. There is no private space anymore. And I think the justices' utter failure to comprehend that is one of the reasons they keep getting caught up in these gotcha situations. You cannot go to a Koch brothers event and not expect for it to be reported. And it's a real problem, I think, for the justices because they really have been so shrouded in privacy for so long and have granted themselves privacy disproportionate to what any other political figure has ever had. But certainly in this era, they're constantly shocked. When Justice Alito is caught going, that's not true, at the State of the Union, and everyone in America talks about nothing else for a week, he's shocked because he's not used to having cameras on him. That was the second time in his life he had cameras on him. The first was his confirmation hearing. So I think that we fail to understand that for the justices, these are intrusions. These are terrible violations. They're not used to being anything other than completely in control of the media. And suddenly, for the first time, they're not in control at all. So the court is trying to cooperate. They're trying to meet us halfway. Well, one of the ways they do that is suddenly they all go on television. When I started covering the court, justices didn't go on television. Between 2006 and today, all of the sitting justices have been on TV doing an interview. All of the sitting justices, plus the former justices, cooperated with Jeff Toobin and Jan Crawford Greenberg for their books about the court. Unheard of before. Justice Thomas writes a blistering tell-all autobiography, his way of getting his story out, his way of trying to control the media. And then Scalia, I think, put it perfectly succinctly in a speech he gave on C-SPAN in 2008 where he said, quote, so this is one reason I've sort of come out of the closet in recent months and done more interviews and allowed my talks to be televised more than I did. I've sort of reached the conclusion that the old common law tradition of judges not making public spectacles of themselves and hiding in the grass has really broken down. It's no use. I'm going to be a public spectacle whether I come out of the closet or not. And so here's Scalia saying, look, I didn't want to do this, but I'm forced to. So here I am, look at me, and I'm juggling flaming torches on television. And so I think there's this sense that since everyone else is doing it, we should do it too. And since we're going to be the subject of a political conversation, we want to be in the conversation. The last thing I want to say about the justices trying to control how they're perceived has to do with the confirmation process. Because I truly have come to believe, and I said this at lunch today, I think I even talked to myself more into it at lunch today, that if you are a judge, and remember that with the exception of Elena Kagan, every single person on the Supreme Court was a judge. The only time in your life you have ever been under the bright white Klieg lights of national television were the 5 worst days of your life, right? The ritual bloodletting that we call confirmation hearings that everybody in the room except the justice who is under the spotlight knows is just empty theater. But for that one justice who has usually spent his or her life having a lot of people defer to them and tell them how smart and wonderful they are, right? That's what judges do. To suddenly have an experience with the press where you are being called a racist and a sexist, where everything about you is being picked over and you are being ritually humiliated on C-SPAN, how would you come away? How would you come away? Because my strong supposition is that as each of these hearings gets uglier and more toxic and more personal and more theatrical, each justice who goes through it is more dubious about the public and the press, and certainly more dubious about television cameras. And if you think that I'm overstating it, I would ask you to read Clarence Thomas talking about his confirmation hearing. I would ask you to hear Justice Sam Alito, who says, I will cross the street rather than walk on the Senate side of the street because of the way they treated me at my hearings. And I would really suggest to you that these hearings are having a backlash effect, where they're doing no good for anyone, I don't think, and what they're doing is persuading the justices that when you let cameras in, people try to punch you in the eye over and over again for 5 days, and that your wife, if you're Sam Alito, or your wife, if you're Clarence Thomas, will never get over it, ever. And so ask yourself whether there's any utility in the post-Bork confirmation hearing that really is about humiliating someone and thinking there's no cost. Because I strongly believe there is a cost. How do I know this? I know this because when Clarence Thomas testified to the Judiciary Committee, the Senate Judiciary Committee, about why he didn't want cameras in the court, he was sitting next to Anthony Kennedy, and Kennedy gave all the arguments he usually give, right? The justices are different, they need to do their work differently, they don't want people to grandstand, all the reasons you would ordinarily hear. Clarence Thomas talked about security. He said we can't afford the marshals. So what is the connection between having television cameras in the court and security? I think it's this feeling that everybody wants to get you. And I think it is a visceral feeling that is not entirely illogical after you've been through the kind of confirmation that he's had. So the last point I want to make, and this is really the substantive policy point, is that I believe that if you read opinions that are coming out of the court, what you are hearing is First Amendment doctrine being shaped by that paranoid fear of the media, television, particularly the new media, that there's a sense on the part of the justices of being assailed by reporters and by the public, and it is starting to shape doctrine. So here are the three, and this is a very recent phenomenon, but I absolutely think that we're going to see it play out in the coming months and years. Here are the 3 data points I can offer you. The Proposition 8 trial, Hollingsworth versus Perry, last January, where the Supreme Court unplugs the district court trial of the Prop 8 hearing in California. 2, Doe versus Reed. This is the Washington State ballot initiative case where the Supreme Court eventually ends up saying, of course you don't have privacy in your name and your signature on a ballot initiative. But Alito concurring and Thomas dissenting use exactly the language we saw in the per curiam, the unsigned opinion in the Prop 8 case, to say exactly the same point. When you put your name on the internet, you're a target. And the third data point is Snyder v. Phelps, which is the funeral protest case that comes down only a few weeks ago. 8-1, the court upholds the right to protest in the most obscene ways at funeral. Sam Alito dissenting, all the same language about verbal assaults and the internet. Justice Breyer incredibly worried both at argument and in his concurrence about how the internet changes everything. So briefly, I just want to tell you what happened in those three cases, and then you can argue with me in the Q&A. In Hollingsworth versus Perry, we have the Ninth Circuit try a pilot program. There's plenty of notice, right? Plenty of period for comment. Justice Vaughn Walker says, we are going to do this trial. We're going to plug it in, not on YouTube, not on C-SPAN. We're going to videocast it to some courts around the country. And both sides, by the way, agree initially that this is fine. And then suddenly, it's not fine. And the Supreme Court steps in an unprecedented decision last January. As I said, an unsigned per curiam opinion saying we can't let this thing be broadcast. Why? There's this incredible, intense concern that the witnesses who might have to be broadcast and be public figures, recall, these are expert witnesses. Each of them is available on YouTube testifying. But the idea somehow that they will be harassed and they will be humiliated and subject to reprisals. And that's the language the court invokes. In fact, the court goes so far as to say, and this is an amazing thing when they unplug the trial, they say, maybe a pilot project isn't a good idea for the cases that, quote, involve issues that are subject to intense debate. In other words, the Supreme Court is saying exactly the opposite of its audio policy, right? The audio policy is we'll only broadcast important cases. But for the Ninth Circuit purposes, they're saying, oh, no, let's only broadcast the really boring trials. And 5-4, the court votes, and blistering dissent by Justice Breyer. 5-4, the court unplugs the case. Why? Remember, harassment, reprisals, very strong language about what happened to proponents of Prop 8 in California who had their lawn signs knocked over and who were subject to economic boycotts, and how harassment is almost a given once your name is out on the internet. Doe v. Reed, this is a Washington state ballot initiative. Washington has an all but gay marriage statute. There's an effort to repeal it. People are standing around at Walmart getting signatures to put your name on the ballot initiative to repeal it. The argument comes before the court, and the people who have put their signatures on the ballot say, I have an associational right, a privacy interest in having my name not be published. Now, Washington state has sunshine laws that say we put all those names up. Everybody who signs a ballot initiative, their names goes on the internet. There's an important check here, right, to make sure that Mickey Mouse hasn't signed it 3,000 times. And this is pretty much an understood, it's been a transparency law, an open government law on the books for years. But the claim is no. Because if I put my name on that ballot initiative, I have a right to privacy. No one has a right to know that who I am, why. Again, read Alito's concurrence, read Thomas's dissent. There's a presumption that the internet changes everything. Alito expressly talks about how you can Google someone, you can find their home, you know where their kids go to school, you know exactly how much they contributed, and you can boycott their business. And Clarence Thomas says, and this is really profound, Clarence Thomas says, dissenting in Doe v. Reed, the state of technology today creates a probability that signers of every referendum will be subject to harassment. So it is a foregone conclusion now for Clarence Thomas that if you sign a ballot petition and your name is out there, someone's going to come to your house and yell at you. That is an amazing, amazing position to take. These are not cases that involve only the idea of associational privacy, but that is how they're being decided, at least by these jurists. The only interest that matters is information and associational privacy, because people will come and get you. Why? Because the internet is different. So that brings me to the third case I want to talk about, which is Snyder. And Snyder's amazing because right before Snyder, I'm not even going to bore you, you all know the case. Right before Snyder v. Phelps is about to be argued at the court, Justice Stephen Breyer, on his mega world book tour, tells George Stephanopoulos that, maybe people who burn the Quran really shouldn't be seen as, this shouldn't be protected free speech. And maybe we should rethink the whole fire in a crowded theater. He gets it wrong, by the way. It's supposed to be falsely shout fire in a crowded theater, but Breyer, by the time Breyer's mashed it up, he's saying maybe the whole world is a crowded theater, and we should really be thinking about whether the internet doesn't turn the whole world into a crowded theater. So he's basically ready to torch the First Amendment as we know it, and George Stephanopoulos' jaw drops a little bit, and everybody goes, ah! But then, in fact, in the case, it becomes clear that Breyer feels that the interesting part of Snyder v. Phelps is not the funeral protest. A couple people with signs, not a problem for him. Nobody saw the signs. The Snyder family didn't see it till TV. Breyer's bothered about the internet because the Phelps, the church, Westboro Baptist Church, put up a really awful ode, it was called, where they personally attacked the family. These weren't their sort of usual McDonald's God hates fags sign. This was an awful slur on the Snyder family and on their slain son. This is what Breyer wants to talk about because in his view, this is an assault. The internet changes everything. And if you watch at these oral arguments, in Doe v. Reed, in Snyder v. Phelps, and in Schwarzenegger, which is the violent video games case that's going to come down from California, there's an amazing split suddenly on the court between Alito and Scalia. And in every one of these cases, Scalia is his chest-thumpy First Amendment, I hate the idea of suppressing speech. My God, he says in Doe v. Reed, we didn't even have a secret ballot in this country until the late 19th century. If you have the courage of your convictions, stand up and say something about it. And if someone throws a rock at you, there's assault laws. But in Scalia's view, speech is to be bold and public, and you have no interest whatsoever in keeping your ideas, your views private. And here's Alito, on the other hand, who's like, well, but they're going to hurt me. Someone's going to hurt my feelings. Or Breyer saying, well, this is really not speech anymore. It's assault. So you have this split happening, even amongst the court's conservatives, and this is not a doctrinal split. In fact, I said this morning at lunch, and I'll say it again. I think if you read Justice Alito's dissent in the Snyder v. Phelps case, what he is talking about when he talks about the horrible, horrible public and the press and the way people use the press to destroy people's reputations, I don't think he's talking about Matthew Snyder. I think he's talking about his confirmation hearing. I think Clarence Thomas is talking about his confirmation hearing when he says, putting your name out there, rolling in a camera, is tantamount to asking people to assault you. So if I'm right about this, and I don't know if I'm right, but I'm just trying to describe a trend that I'm seeing at the court, which is a real anxiety about the media, the press, absolutely the internet, about transparency and openness, then the final chapter in my story is that last June the court, for the first time ever, locks the front door. And the big ceremonial front door that has the big, now ironic words, equal justice under the law, written over them are locked to the public. So that to get into the building, you have to go around the side. Why? Again, unspecified threats, some sense that the public wants to harm us. And so all of this is happening, and I think we're failing to notice that we are no longer having a conversation with the justices because I think they're running away from us. They're making it impossible to be in a conversation. So now I think there are 3 and possibly 4 justices who have been sufficiently bruised by the confirmation process, sufficiently embarrassed by gotchaism that's happening in the media, that they are turning on the media, turning on the internet, turning on the public. And it is informing the way they think about privacy. It is informing the way they think about their own privacy and the way they think about your privacy. It is informing the way they think about free speech, their free speech and yours. And I think it's going to be a vicious cycle. If I'm right about this, we'll see how the Schwarzenegger case comes down. But if I'm right about this, and there's a feeling increasingly at the court that new media is so dangerous, so pernicious, opens us up to such new and unprecedented attacks, then we need to be in that conversation with them. We need to figure out a way to undo that. Because I think if we don't have this conversation now, as every confirmation hearing gets uglier, as every justice feels more trapped, more called out, more embarrassed, we are going to see the doors that have quite literally been closed further and further. So that's what I had to say, and I am very, very happy to take questions or comments. Way at the back. Wait, hold on.
Do you feel that there is a level of trust at all between justices and the long-term Supreme Court reporters, such as yourself and people that have been there for 30 or 40 years? I mean, you talk about this fear of the press and new media. Is there at all any level of trust between the people who have been reporting for a long time?
Trust is an interesting word. I mean, I think there is certainly an agreement, a tacit agreement, that we will not call them out, we will not shame them, and in exchange for that, they will let us keep coming into the building. You know, I think that's been the agreement, and that is the current agreement. I think that what they're reacting to isn't, I don't see a dramatic change among the 20 or 30 people who cover the court regularly, other than the fact that there are fewer of us than ever. That number shrinks every year, and that's a problem. I think that there is an enormous amount of trust between the justices and the permanent press corps that we won't embarrass them, but I think that we don't matter like we used to. Because of this explosion out in the world, they're not worried about me. They're worried about Jeff Toobin, they're worried about Jack Balkin, they're worried about Glenn Greenwald, they're worried about Ed Whalen. Those people don't come to court. They don't need to. They can get the transcript at 3. And I think that's what's worrying the justices, is the advent of a whole conversation that's happening out in the world that they have no control over. Okay, now.
How do speeches like the one that you just given fit into your job of downplaying the individuality of each of the justices?
Well, I don't think it's my job. The press corps, I think probably most of us wouldn't give a speech like this. I mean, I think that most of us probably give you a speech about footnote 2 in the Green Brief. And that is not to make fun of the press corps, but just to say, and this is really a tribute, I think, to Linda Greenhouse, who really created a form. I mean, the way Linda wrote about the law is the way we all write about the law. And it's just very scholarly. And it can't be an accident that Linda waited to leave that position before she starts writing her opinionator column, in which she says, oh, thank God, now I can tell you what I really think. And it's just a download, you know, of just, here's 30 years of what I've always wanted to say. And I think that's a pretty good example of the way which we feel like we have to hold our powder for years and years and years, and then just sort of breathe it all out. And it really is different from other press corps. I mean, I strongly suspect that if, you know, Candy Crowley were here, she would give you a speech that is not unrecognizable from what she does in her job. But I think that, you know, I was telling Keith today, it's very interesting in the Supreme Court press corps how often I walk into the room after an argument and someone says, oh my God, you totally have to write about. And I'll say, well, why don't you write about it? Not me, but you. You have to write about that. And it tells me that there's a deep sense that we're self-censoring. And I think it's, as I say, it's a good thing because I think we're doing important work. I think it's a bad thing when we're letting the court slide. And one other thing that maybe another data point for you to filter into all the data points I've given you is that if you watch who covers confirmation hearings, it's not the Supreme Court reporter. If it's the Supreme Court reporter, like they're up in the balcony, you know, like reading Kafka, they're not really covering it. The people who are called in to this was a huge surprise to me. Because I thought all my buddies would be there, and I would get to see them in a room that had light, you know, instead of the Supreme Court. It's very dark, the ceremonial courtroom. You have to, it's like an Italian restaurant. You have to blink around and try to see, so you don't actually know what Tony Morrow looks like. So I was very excited to actually be. Here I am. I'm in the Senate. The lights are on. I'm going to see my colleagues. Many, I would say most of them aren't covering it. This is not a court event. This is a political event. When Ginny Thomas, for reasons I cannot articulate, calls Anita Hill at 7 o'clock on a Saturday morning. They didn't call the press corps for statement. What were we going to say about that? Is it in the briefs? But it's a political story, and they call political reporters. So I think this kind of bifurcation of even the court itself is part of, we've relinquished that part of the conversation to other people. Okay, more questions, yeah.
If the current confirmation hearings have created this type of bunker mentality, how would you suggest the Senate do it differently to avoid some of these issues? I mean, is there a way that they can possibly?
I would go back to the good old days. I mean, until very, very recently, this was done on paper. The justice didn't show up at all. You know, I was saying today, William O. Douglas was begging to testify at his hearings, and nobody would let him in. So I think the first thing is to take out this person who's sitting in the room with his thesaurus in his head, trying to find 500 different ways to say, I'm not going to answer that, I'm not going to answer that, this is not interesting. You're not going to learn anything. So I'd say take the nominee out, and then I would say turn off the cameras. And do it in private and do it on the books. Because especially given the narrowness of the experience that we are going to permit in a nominee today, we're not going to let anyone interesting ever be on the court again. There will never be another Hugo Black. There will never be another Thurgood Marshall. So if we're only going to pick people who are hydroponically raised from birth to be confirmation worthy, why have a hearing at all? Yeah.
I wonder if you could touch on your prior experience, if any, with justices' clerks, and if you feel like they ever use them as sort of a buffer or a shield with you guys at all.
Almost not at all. I think the justices' clerks they're dead to us. For those, for that year, they don't talk to the press. I think if the press calls them, they don't answer. I've had friends who've clerked at the court who just cut me off that year. I'm dead to them. So there really is a very, very strong feeling at the court. I had this clerking at the Court of Appeals, too. We didn't talk to the press. We just didn't. There's not a relationship there. If we want to talk to the justices, we try to get to the justices. If the justices want to talk to us, they frequently go through the Public Information Office or some other way. But it's not, I think that the clerks are not a part of the triangle, not the way they were in the Brethren. Yeah.
You kind of touched on this already, but do you see either side's roles during confirmation hearings changing in the near future?
Who's either side?
The Senate or the Congress?
I think it could only get worse. I mean, I think, we are in a feedback loop where the senators, I don't know that they ever thought they could elicit interesting information. My guess is no. I mean, there are things you can do. Stephen Carter at Yale and other scholars have said, here are ways to rejigger the process that would perhaps lead to some more substantive conversation. You can hire lawyers to ask the questions. If all the senators worked together and produced a list of 100 questions rather than all asking the same 3 questions, there are things they could do that could elicit some meaningful information. But I think they know that the nominees never, ever, each of these nominees got an A+ at Harvard. They're not going to be trapped. And they've been murder-boarded for weeks to within an inch of their lives, and they are not going to, so you're not going to get that. And I think the more the process frustrates them, the more they use it a way to talk to the people back home. And so it really is a television opportunity. It's amazing to watch them when the C-SPAN cameras are on at the back of the hall. There's no one listening to the questioning. They're just all like, whoa, C-SPAN, go, and they're all talking. And it's like being in the room is immaterial. So I don't see it getting better. I think, the great, emblematic story is Elena Kagan, who writes the definitive takedown of the confirmation process and calls it, a shallow farce. And everybody says, awesome, we're finally, and how great the Bork hearing was, because we all learned about the Constitution. What a teachable moment that was, she writes. And then, she gets up in front of, and everybody's so excited, and she doesn't answer. So I don't see this getting better. And I think there's a way in which, as the stakes rise, and it's really an interesting problem in this country. We talk about race and gender so comfortably at these hearings. It's really interesting to me that when you used to have hearings, right, when Brandeis he was the first person who came to his hearing, it was all about the fact that he was Jewish. That was what was freaking everyone out. Religion is off the table, right? We have 6 Catholics and 3 Jews. We can't ask about that. But man, are we talking about race and gender in this country. And so Alito's a racist, and Roberts is a racist, and Sotomayor is a racist and a sexist, and Kagan hates the military. So I think one of the things that's very, very interesting is how these hearings have changed to map onto things that we're anxious about that have absolutely nothing to do with the law. So I see, again, that's going to degenerate. I think the worst thing you can call someone in America, the worst, is a racist. And every last one of the last 4 hearings, with the exception of Kagan, we've called someone a racist, usually with their wife and children in the room. Okay, yeah.
You've choice made by the two opposing parties to put forth justices who are of that nature. So I'm not exactly understanding, or maybe they're just not registering this. They are putting forth individuals whom they don't seem to inform they're going to get battered in a confirmation hearing. And I just have the comments of why, I guess this is more on politics than on the court, but why is it that political parties care to put forth these cabbage patch as their justices?
Well, the president and the parties have one interest and one interest only, and that is getting this person confirmed. I mean, that's it. And you may remember, I mean, the best example of this is President Obama, who test drives the concept of judicial empathy, remember, with Sotomayor? And he actually is trying to have a conversation with Chief Justice Roberts to debunk the umpire theory, to actually engage in a constitutional conversation about what is missing at the Roberts Court. And so he tries out empathy. And then Sonia Sotomayor, his nominee, who, by the way, was set up, because as soon as he said, oh, the quality of empathy is something she brings to the bench, she's immediately going to be tagged as a racist and a sexist. He did the work for her opponents by saying that empathy, because that means she's biased. And bias means you're biased for people who look like you in this country. And so the minute he said that, he set her up to do exactly what she did at her confirmation when she was asked if empathy is a quality that matters in a jurist. She threw the president under the bus. She's like, oh, no, that is not, if that's what empathy means, I want nothing to do with it. I'm in the John Roberts, brain in a vat camp. I am an umpire. So I think that, and you can't be mad at her for throwing him under the bus. She needed to get confirmed. You can't be mad at the president for trying to have a moment where we have a conversation about what the courts do. But I think that we have come to a point where the nominee has one job, and that is to get confirmed. And that means not only that their resume is going to be paper thin, they are going to have spent their entire life not telling anyone what they really think, but it also means that those are the only people who can get confirmed because they all have to be like John Roberts. Every time a nominee narrows the bandwidth about what is on the table, what we can talk about, it's narrow for the next person. So I think it's really, 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 it's like maybe the bandwidth is the wrong way to talk about a limbo stick. Nobody can get under that stick if they have ever said or done anything interesting in their lives. And so, should we have, a former defense attorney? Should we have a capital defense lawyer who's done nothing but death row cases for 30 years on the court? Heck yeah, we totally need that person. We need a person who's been elected to office and given crazy speeches and is on YouTube like Jennifer Granholm saying insane things time after time. Of course the court needs that. We will never get that person on the court again.
I guess my response is the question of whether politicians like President Obama are actually making a good faith effort to actually have that conversation, or is it, a setup where the nominee can knock it down, she looks, distinguished and non-political, the president can make a remark about trying to have a conversation and we go on our way.
Maybe. I think that what President Obama was doing, and I think he pulled that thread right through his objection to Citizen United. I mean, he's trying to answer a very, very specific problem he sees at a court that he thinks is unkind to real people and that is pro-corporate and that doesn't have a heart. And I think we've seen that enough in his rhetoric that I think it is a good faith attempt to say calling balls and strikes isn't enough. Now, I don't think the president in a week before a confirmation hearing can have that conversation. I think it is a conversation everyone in the country needs to be having every minute of every day. But that's because I read the green briefs. I can take one more. Yeah.
In what ways is Anthony Lewis and other early court reporters impacting the way that you report on the court today?
Say it one more time, I'm sorry?
In what ways have Anthony Lewis and other early court reporters had an impact on the way you report today?
I think I think we all read Gideon's Trumpet and wanted to go to law school. I mean, I think that this is a press corps that I think is very, very passionate about the law and really believes in justice and using the law to do good. I think it is probably an overwhelmingly liberal Supreme Court press corps today. But I think overwhelmingly the person who has shaped the way we report on the court is Linda Greenhouse. I mean, I think she, as I said, I think she created a form. She really created a model about the sort of dispassionate middle distance, report on the facts and report on the law, and not your opinion, and certainly not personalities. Remember, Tony Morrow a couple of years ago tried to do a story on clerk hiring and how few of the justices hired minority clerks. It wasn't just that the justices were enraged, and this is not a story. There's no story here. The other people in the press corps came out against him and said this wasn't a story. So I think that this is a press corps that has a very, very passionate view of what it is our job to do. And that is report on the law as the law, minimize the justices' ideological differences, and to really, I think, and this is the sort of beautiful part of it, do the work of preserving the integrity of the court. Remember America, that the court has no purse, it has no sword. If, Americans decided that the court doesn't matter, there would be no court. And that's how it's different from the other branches of government. That's why the court itself wants to tell the narrative about it being a secular temple. And I think that's why we're complicit in telling that story, too. We love the court. And we report on it, I think, in ways that sometimes obscure what the court really is. I want to thank you very, very much. You have been very